I'm the Assistant District Attorney here. Welcome, everybody. We've got what we've sort of titled as a training. What I'd like to do is have more of a discussion. What I wanted to do is start by maybe just going around quickly. I'd like to have you all introduce yourself and the agency that you're from so that we all kind of have some familiarity of who each other are. And what our objective here this morning is to really introduce you to an element of our office that we're really proud of. We have two separate, within the District Attorney's Office, we have two separate statutorily created boards that we administer here in the DA's office that I'm personally very proud of because it gets me away from some of the routine and really challenging things that we do here in the office. One of those is the Crime Victims Compensation Board. And Jamie and Nicole, who are friendly employees who introduced themselves to you here this morning, are really the foundation of our CVC board. Jamie and Nicole have been here a decade almost and have really managed our Crime Victims Compensation Board well. And this morning what I want to do is obviously highlight and talk to you about the board and how we process things. Obviously I don't know all of your backgrounds and familiarities. I'm sure some of you are well familiar with CVC and what it does. So I really don't want to stand up here and do some sort of a training for folks that don't need it, but more importantly, for folks that aren't familiar with CVC, I do want to talk about what we do and really engage in, like I say, a discussion. We've got a PowerPoint to help guide us that Jamie and Nicole have really helped me put together, and I want to identify for you and your agencies what are concerns, questions, issues that we can help answer out of this, at least this morning's discussion. The other statutorily created board that we have in the office, as you well know, is VAIL. And I'm also very proud of our VAIL board. The boards function in very different ways, but they're similar in that we involve volunteers from our community to be on these boards who really spend a considerable amount of their time in different ways, but for victims of crime, and that's really what this is all about. And so I'm really proud of the work that we do here. I kind of introduced you guys, but I'll let you guys put a name to the face. I think you kind of introduced yourselves as well, so go ahead, please. Hi, good morning. Go ahead.
I'm Nicole. I work at Crime Victim Compensation. I'm part of the program.
I'm the part of the program. My name's Jamie, and I think I've talked to probably the majority of you guys, but it's really nice that you guys are all here and I can put a face to your or a name to your face. So thanks for coming. Welcome.
Thanks, ladies. Please sit wherever comfortable. I'm going to go ahead and start over there on the other side of the room. If you could just tell us who you are and what agency you're with.
My name is Jennifer Holt. I'm an advocate with the Thornton Northland Police Departments.
Sarita Montano, victim advocate with Thornton Northland.
And Terry with Ralston House.
I'm the director of Courage with Family Tree.
I'm Jenna Willis. I'm the director of the Parenting Tech Program at Family Tree.
Jalen with Adams Sheriff's Office Victim Services. Amy Urick with Catholic Charities, director of our emergency assistance programs.
Hillary Lancaster, victim assistance with Catholic Charities.
I'm Tamara Bourne at Reaching Hope. I'm a psychologist in one of the EDs.
Aubrey Austin, psychologist and ED at Reaching Hope.
Scott Coleman, advocate, Broomfield Police Department.
Tanya Ortega, advocate with the Brighton and Commerce City PD.
Johnny Vera with Brighton and Commerce City. Christina Gunn with Brighton and Commerce City.
Soledad Diaz, I'm legal advocate for SPAN.
I'm Emily Brockman, the senior staff attorney in the children's program at Rocky Mountain Urban Advocacy.
Great. Welcome again, everybody. Thanks for being here. And also, should go without saying, but I do want to emphasize thanks for everything you do for victims of crime in our communities, whether it's advocacy or through your programs offering services to families and victims of crime. It's important to what we do. The Crime Victims Compensation Program is, as I mentioned, it's set up through state statute. All 50 states have a crime victims compensation program. Ours is over 30 years old, actually almost 40 years old. We, here in our office, we've had a well-established victims compensation program, one of the first in the state, and I would say one of the most or best managed. We process over 2,000, actually well over 2,000, 2,500 claims a year about. And in terms of payouts to victims of crime, again, well over a number of 2 million. I think we're 2.3. So we process a lot of claims, and when I say we, Jamie and Nicole, and the board, of course. So just to kind of give you a sense of what the board does, is the board determines eligibility based on certain factors, and these are set forth in statute. There's more or less, after a crime, there's an eligibility. There's eligibility determinations, which include the actual crime. Is it a compensable crime? Is it a crime that fits within the statute or the interpretation of those crimes that are eligible for compensation? There's also an assessment of the victim and the Victims Association and other eligibility determinations. An application is submitted with supporting documentation. The supporting documentation generally is police reports or victim impact statements, various receipts, bills, necessary expenses, those sorts of things. The board meets once a month. I'm going to talk about in a little more detail about the logistics of the board meeting, but the board meets once a month, excuse me, and considers the applications for compensation and determines eligibility, and then we start the processing of those claims. Sometimes those claims aren't that simple. In fact, more times than not, they're probably not that simple, and so they involve multiple considerations by the board and by our staff in terms of not only statutory eligibility, but actual payment and coordination with the service provider, whoever that might be. We can also seek restitution. Restitution is financial compensation made through the court system for losses associated with crime. Restitution is sought following the disposition or the completion of a crime. Ultimately, what we're talking about there is sentencing. After an offender is sentenced for a criminal conviction, then the prosecution can seek restitution. Crime victims compensation is a recognized victim under statute of restitution. So crime victims compensation can seek reimbursement of the expenses that were incurred as a result of the payouts in this application process. The statutory considerations really can be narrowed down into the four, which is the crime, whether the crime is an eligible crime. The eligibility requirements include an assessment, as I mentioned, of the victim and the Victims Association or relationship with the crime. The compensable loss, what is the loss that the victim is seeking, application for reimbursement or for payment, and the eligible party. There's considerations as it relates to the victim, and that is whether the victim had contributed or in any way provoked the incident that resulted in the loss. As you can imagine, I think it's really complicated when you're talking about board members who, we always have one law enforcement officer sitting on the board, which has been particularly helpful. And a lot of times we have folks who have some former or current connection with victim services, but these are citizens in our community. And so a lot of times sifting through police reports and really trying to identify eligibility through the statutory requirements, it can be challenging. We also have a set of policies and bylaws within our jurisdiction that help us process claims within Adams and Broomfield counties so that we can further streamline the way we manage these applications. Amongst the eligibility requirements are certain statutory prerequisites. Victims have to be cooperative with law enforcement. Crimes have to be reported within 72 hours of the incident, and the application has to be filled within 1 year. Obviously, the crime must be in our jurisdiction, so we don't have authority outside of Adams and Brookfield counties to consider applications for claims.
Just any quick question.
Yeah.
Sorry, I just wanna, this is like my fourth, victim compensation.
Welcome.
training.
How am I doing so far?
Great. I just wanted to confirm, because a lot of my clients, as you can imagine, are undocumented and they don't necessarily report crime within 72 hours because of fear, being referred to ICE. And I know previously it had been mentioned that those considerations, that can be taken into consideration to waive the 72-hour requirement if they can show that it was because they were
Yes.
afraid to come to law enforcement, and that, for example, an advocate at our office said, no, like, you have the right to go to police, like, you need to go to police.
Yes. It's a great question. All of the eligibility requirements, especially those, the nuanced ones of the reporting within 72 hours, can be waived by the board under the statute upon a showing of, or upon a determination of good cause. What is good cause? Is the question. Something such as not being documented and natural fears of reporting fears, those sorts of things, I would imagine the board would find good cause. Of course, the board makes those determinations on a case-by-case basis, but all of the, there's certain ones that we wouldn't be as, we wouldn't consider as flexible a finding of good cause like the application. So we would really look to what were the circumstances that kept us from having an application within 1 year of the crime. But the reporting, certainly, under your circumstance and your question, that would be something that I think the board would strongly consider good cause. One of the, I think, more challenging ones is the victim's involvement. And at the early stage, often when these applications are considered by the board, we don't have a criminal case filed, or it's in the process of the investigation. And so I think that becomes challenging. And so we do heavily rely on the advocates in the room and our law enforcement partners to help us understand and help guide us through victims' relative posture and situation with respect to the crime, because it does become challenging to try to sort out where is this case going if it's not a filed or yet filed case. A compensable crime, this is the statutory definition. It includes an intentional, knowing, reckless, or criminally negligent act. It also includes driving under the influence offenses that result in bodily injury or death. Also these crimes that result in loss or damage to medically necessary devices. In 2015, the legislature added careless driving that results in bodily injury or death. The specific crimes are laid out in this slide. Is that better? I'm not going to read through all these crimes, but safe to say, with the broad definition of crime, including intentional, knowing, reckless act, really encapsulates all of our assaults, all of our homicides, all of our violent crimes. Where it's particularly challenging, I believe, are in the assessment of the accidental type of cases, and obviously traffic crimes also, which is why I think we're real fortunate that the legislature had broadened it to traffic crimes involving bodily injury or death, in particular careless driving. And as you can imagine, we have a high volume of those types of cases. Last year we filed, I think, just under 35,000 traffic and misdemeanor cases in Broomfield and Adams County combined. Those aren't all careless driving, but there's a large volume of traffic offenses that involve bodily injury or death, and obviously DUI is a significant consideration. But you can see amongst these lists, it captures almost all of our violent crimes, obviously domestic violence, and those other sorts of crimes that might involve losses. Included in this slide are the
Can I ask you a
various
quick question?
traffic crimes. Yeah.
For the last one there about protection order violations, does that apply whether it's a criminal or a civil protection order?
Jamie, Nicole? Yes.
Thank you.
Question. Traffic crimes are included here, which I think we kind of mentioned. Obviously, there's more significant ones as well as the careless. Compensable losses.
Jess, I think we still have some more questions regarding that last thing. Go ahead, can you say it to everybody?
That violation of protection order, are you accepting that? I mean, cause civil, as long as it's stemming from domestic violence or sexual assault or a VRA crime, but are you taking that if somebody just comes in and gets a civil protection order against a neighbor, that's not gonna
We have
fall
actually.
under-
Yeah, we have.
Yeah. Again, it's case by case, but we would absolutely have to move on and then we take it to the board.
Okay, cause that's something definitely everybody's gonna need to know, cause I don't think that the law enforcement, you do the stuff that's tied to a criminal event, the civil side of things is outside of the law enforcement jurisdiction, so unless they're violating the civil protection order, then it becomes a crime, but civil stuff we're not gonna know about.
But this is if they violate that.
Yeah,
protection
so
order, and then
then it
there is-
becomes a crime, but
Yeah.
typically it's not gonna fall under VRA unless it's tied to domestic violence or stalking. And we've always been taught that the victim's compensation is tied to VRA crimes, and VRA crimes only.
And so you're saying that but when they get the civil protection order, they would be listing some sort of DV or SA in that, so it would be tied, it just wouldn't be a reported crime, right?
So if there was a tie to, domestic violence, stalking, or sexual assault, actually, I guess I should throw that in there. Then there would be, I mean, that's the VRA part of it. But if you have a neighbor dispute and they get a civil protection order against each other, it doesn't become a crime until the neighbor violates that, and then we would see that we have a civil protection order violation. But typically, we wouldn't reach out to that person because it has nothing to do with a VRA crime. So I didn't know that
But
you
with
were
that,
taking those civil.
that wouldn't count, right, because it wasn't a sexual assault between neighbors, it was like a dispute, so that was.
Right,
And that would, yeah, cause that would not be a VRA
Yeah,
crime.
exactly, it would have to be tied to a VRA crime, exactly.
But even if they haven't reported it, like it was DV and they don't have police reports, but they went in and got a civil protection
We
order.
have to have a police report regardless.
From the, like,
Absolutely.
so there has to have been a police report.
So if there was a
initially, just like-
dispute between the neighbors and that prompted the protection order, we could actually accept their application and we take it to the board, because if there's an issue of self-harm, between the two neighbors, absolutely, let's take it to the board and see what they would say, because again, that's our safety. So yes, I would say have them apply, especially with the police report, we have to have a police report.
But if there wasn't self-harm and it was just threats that were made between the two, and this person says, well, I wanna go get counseling because this threatening behavior is bothering me, there wasn't any bodily injury, but they're wanting therapy because this is really, it's bringing up some stuff from the past, they're really struggling with it, is that something you guys would consider?
I would say yes, because
If
there's a
they violated
safety,
the
because
protection order,
yeah,
or if
because
they
there's
sought a protection order?
safety issue there.
Let me just jump in here. So the statute requires that as a compensable crime, an intentional, knowing, reckless, or criminally negligent act of a person or any act in violation of the traffic code that results in residential property damage to or bodily injury or death of another person, or results in loss or damage to eyeglasses, dentures, hearing aids, or other prosthetic or medically necessary devices, and which, if committed by a person in full legal capacity, is punishable as a crime in the state. So a violation of a protection order, whether it's criminal or civil, is a knowing crime, okay? The question becomes, does it result in loss? So regardless of whether it's DV, whether it results from a criminal filing, or whether it's a Title 14 protection order, or Title 13 protection order, then it would have to be it's obviously a knowing crime, but then it would have to result in a loss. So, in terms of whether the board would pay out, we come back to the statute, okay? So, is it a compensable crime? It's a knowing crime, so yes, but then the next question is, did they go across the fence and break the fence in the course of violating the civil protection? I don't know. Are there psychological or other sorts of compensable losses? Then I think the board would consider that. So, VRAs, you're right, automatically we meet with them and you give them an application, but the ones that aren't VRA, those are the ones that are, once they get over here, then RDAs really would need to process, is this someone who would be more or less eligible to at least fill out an application that the board would consider. So, I think there's probably a lot of, obviously, nuance within that, but I think ultimately, under the statute, there is eligibility. The question becomes back to the board, what are the losses? I think is more of a critical question. Does that help?
And I would say, like, when in doubt, just have them apply. Let them know that it's not like guaranteed, but it's not gonna hurt anything if they apply.
And that's what and I appreciate that comment. That's what we try to emphasize throughout our office and our victim advocates as well as our RDAs is it's the application that's important, and then all of the technicalities of whether it's compensable and whether it falls under the statute, we leave all that to the board.
Can I ask along those lines? I think the board in the past has accepted applications that beyond that 1 year filing period, especially for adults who were sexually abused as children and don't have the opportunity to report themselves as kiddos, but as an adult, maybe they then file a report. Is that something you guys are still accepting?
And the statute also recognizes unsolved crimes. So when there's, sometimes there's a delayed outcry, that would be in the context of an unresolved crime. So it wouldn't technically go back to, the day-to-day offense, for instance. And then we obviously have that broad good cause provision where we can evaluate the circumstances. What's most important, I think, in those situations is communication. Information from the victim and the communication from you all as far as the details or things that the board should know. Good questions. What else?
Is there any other crimes then? Pittsburgh 2 is also not a VRA crime, but we send in a lot of compensation apps for the doors, locks, windows. Is there any other non-VRA crimes that we should be?
Yeah, that's why I think it's important to recognize all the traffic. Yeah.
This could open up a lot more applications that we send in. We've always just been told VRA crimes only. Other than the Berg 2, that was the only exception.
Yeah, the statute is quite broad. Again, it comes back to the loss, I think, which I know is a tough situation to try to not provide an application because there is no loss, or you don't identify a loss. But I think the statute is quite broad in capturing all of the potential knowing or from reckless criminal negligence crimes that are all compensable. So the losses are broad, and our bylaws have further narrowed some of the things that the board would consider in terms of a compensable loss. There's an entire range of therapy. There's obviously medical expenses, dental expenses, medical necessary devices, hearing aids, eyeglasses, dentures, those sorts of things. The maximum under the statute is $30,000. The board has a limit of $20,000. I think it's in a later slide, but we're funded through federal and state resources. Federal is through a grant fund that fluctuates, and it's dependent on our federal government and the amount of award that we get monthly. Depends on the number of claims that we have. It's a really complicated process that we owe a lot to Jamie Nicole to help us identify monthly the value or the numbers that we request from our federal resource. The state funds are tied to collections on criminal cases, so criminal convictions and assessments or fines, court costs, because they're generally categorized at the time of sentencing. So, the reason I bring all that up is, within our available sources and given the number of claims, and you heard the number of payouts that we have, we've got to narrow our maximums, and the board does a really great job in really trying to identify the absolutely necessary expenses and payouts, as well as having limitations that are under our 30,000. So they spend a lot of time really trying to narrow the statutory maximum and identify the necessary expenses. As you can imagine, and as you know, actually, our homicides, we've got a significant number of them, and funeral, burial expenses take up quite a bit of the amounts of what our payouts are for victims. Doors, locks, and windows, the statute identifies those as covered losses as well.
I have a question on
Yeah.
that. Like, we get a lot of BB gun shots to windows, on double pane windows, and it only cracks that exterior window, and it doesn't, is that still do the application, or it's still considered safe because one of the sheets of glass is still protected?
Yeah, if you've got if you've got an identified victim who's got a compensable crime.
I just didn't know because it was still secure, the house was still secure with that other piece of glass still being there, but I just never knew.
Yeah, obviously the board looks at those safety considerations, and that's one of the things in terms of the policies, and Jamie Nicole speak up here. But, we try to identify, the statute says, changing of locks, and there's a limitation that, there's the added motor vehicles, changing of locks and then certain damage to motor vehicles, which may include some of the vandalism types of cases that you're talking about. So it's not just tied to safety, but in terms of the question of whether it's a compensable loss, I think the board oftentimes looks at the victim's request as it relates to those sorts of payouts. Is there more that I'm missing with that?
No, so just under this one, we consider doors, locks, windows, door locks, especially in DV situations where they've stolen the key fob thing, we can replace or get the rekeyed. And then as far as your window question, yes, we would consider the window on BB gun shootings as we have in the past. And then security systems, again, for DV or sex assault cases, usually. Or burglaries, I should say, mostly.
And within those, especially property sorts of losses, the board sets certain limitations, maximums for compensable losses within the policies, or in the bylaws, I should say. Funeral and burial, as I mentioned, is a large volume of our claims and a large volume of the payouts. The board will approve up to, it's 6,000 for
6,000
funeral?
for funeral and 4,000 for burial.
So there's a maximum of 10,000 for funeral and burial expenses. Obviously that contributes to the overall maximum that the board will pay out, 20,000, and the maximum under statute of 30,000.
How are you guys handling the GoFundMe accounts and donation accounts and things like that? In addition to, are you having them pay for that first out of their pocket and then applying the 10,000?
We don't actively go on Google and search to see if they have a GoFundMe account, but we do have paid out on them. And I know that you and you kind of discussed this with the supervisors last year about we're kind of just going business as usual. We're paying out on funeral and burial, but we don't actively seek out. I think that what was it, Colorado Springs or something, did something like that. We don't really necessarily want to.
It gets real complicated. And my view is I don't want our board, diving into that mess. The statute recognizes, an offset, that, you know, a claim must be made through insurance, for instance, not your example, but a claim has to be made through insurance for certain losses first, prior to, the board paying out, and then the board will cover the deductible, or to the extent insurance doesn't pay, the board will pay. That's an easy one because we've got, you know, there's a entity that you can get documentation from. The ones that's more challenging are GoFundMe, and when people hear GoFundMe, it raises certain suspicions too, as to, you know, how is that money being used, or who set it up, or for what objective. It's been my sort of guidance to our board not to wade into that, because it gets particularly messy, because I think then we end up treating people differently, depending on whether they have a GoFundMe, or whether their aunt was savvy enough to set up a GoFundMe, or whether they are taking advantage and setting up a GoFundMe. I'd rather our board not wade into those issues. What I will say though is we've seen our courts of appeals, our courts that review the legality of restitution and the application of crime victims compensation have been very critical of victims in terms of offset. So in other words, if a victim, we've had a couple of cases that came out of this jurisdiction, a victim actually receives a civil settlement as a result of a lawsuit, for instance, a civil lawsuit, and also receives compensation, whether it's through restitution or crime victims compensation. The Court of Appeals and Supreme Court have been very strict on victim is accountable now to pay back. And it just doesn't sit well. Obviously, you've got a victim who's out a loss and may not ever be put back in the position. The least we can do is help with financial coverage. But then down the road, you know, there's a criticism of they grab too much financial. So I really don't want our board to wade into all that. And so I'm kind of yammering on, I guess, here, but I think safe to say it's one of those situations that I think other boards are dealing with in other jurisdictions. And I'm not sure actually how they're dealing with those types of issues, but we've kind of just guided our board away from that.
How does that, because I know that's a question on the application about whether they're intending to file a civil lawsuit, so what is the board doing with that question on the application?
So the board has to, what we have to do is, while we're not representing the victim, more or less what we're doing, and my guidance to our DAs are to keep, recommend that the victim keep an accounting of the information, because obviously the board's consideration is confidential, everything in the statute in terms of, obviously with the medical records and the therapy records and the HIPAA sorts of things, but also considerations as far as the documentation, the review, and receipts and payouts is confidential, but it's subject to court review. And so ultimately, if there is a civil settlement and there is a CVC payout, and then we've sought restitution to reimburse CVC, then it gets real messy, and the defendant can then seek restitution, or can seek offsets of restitution. So if the defendant has to pay out $50,000, say, then there's, you know, we look at CVC, what was the total CVC payout, and then CVC has their records, which were confidential, but then the victim got a settlement, and so the victim is going to have to testify about what was the settlement for, and how, you know, was it duplicate on medical, and so who's to be paid back. So our recommendation, in short, is it's just good for the board to know and be aware, and so to the extent that there is a settlement, then the board can simply say, you know, in a confidential setting, what was the settlement and what were the payouts, so they can reconcile, rather than, because once it gets, and I put it up here because of the courthouse, but once it gets up the hill, we can't control what the judges are doing. And we've had a lot of situations where judges are demanding all records, and then we have to file these standard responses, and then I really don't want to have certainly our board members, but my staff, to testify, this is what the board did. It just really gets messy. So the best direction we can give victims, I think, is to keep an accounting and not freak them out, but to keep it accounting, you have a right to seek a civil, judgment or civil action, but to be aware that you can't collect multiple times, and I think people get that. It just gets especially messy, we've seen with, and I think that's part of why we asked that question. Do you guys want to add to any of that?
We also have them at the back of our application, they do have to sign an initial subrogation agreement, that we also send out to them, and it's just a reminder to let them know that at some point, if they do receive a civil settlement, that we are back our money at that point.
Now, the application is on behalf of, like, so if we're talking homicide, the application is on behalf of the deceased party, and these people, the family members are acting on the behalf of that person. But if the family is doing a civil suit saying this affected me personally, is that still tied? Because that's technically their money saying you affected my life, this is something totally separate than acting on behalf of the deceased party.
So when we send stuff to the DAs across the street as far as the restitution reports go, it's gonna include everybody under the same court case. So the judge is gonna be aware of everybody that we're requesting restitution for, so it's all kind of lumped up together, even though they do have individual claims, but that's what we send over to them, so they just have knowledge of everybody that was involved in that. That's our case.
And I appreciate you guys answering these questions, because on our ends, they're asking us right up front, like, how am I gonna pay for this funeral? How am I gonna do all this? How is that gonna affect the crime victim app? And they're looking at us like we have all the answers.
And please,
Yeah.
forward them on to us.
And we usually do, and we
Yeah.
usually give them your email because it's easier for them for you guys, instead of blowing up your phones. But when they're saying, well, I've got this GoFundMe, is that gonna affect how much I'm getting back? I'm like, so I don't wanna say the wrong things. We will act however you guys are instructing us to act, so that we're all on the same page, but we get so much on the front end.
Jalen, I think the best guidance, and this is what y'all I think are doing, is you may be eligible for
And that's what we have
compensable
always
losses.
said, there's no guarantees.
And the ones that are obvious are burial, funeral, and medical. Those are the first two obvious. Then there's, therapy, counseling, I mean, all kinds of, a whole host of other things that I think they may be eligible for. Could include loss of earnings, could include, all of their dependents, loss of income for whatever it is, 4 weeks, 4 months, I don't remember the number that our policies are. But it could include a whole host of things. But in terms of the civil, that they should know that you can't collect twice. And that, I think people get that. And so, to make it
They get that, they just try so hard anyway.
Logistically though, what I think happens, or you should know, is when CVC makes a payout, let's say there's a $20,000 payout, and the $20,000 includes funeral and medical. The note that, or the record that goes to the court is $20,000 CVC, funeral and medical. It's identified, and so the actual portion of which is more detailed, and sometimes, and we actually probably sort that out, but in terms of what the medical was and all of those things, that's the stuff we obviously keep confidential. To the extent that then there's a civil award or settlement, that's where it gets really messy. Did it involve funeral and did it involve medical? It might have involved some medical, but not the medical that's CVC. That's where it gets really messy. And so I think our best guidance is you may be eligible, but you need to keep track of things so that the board doesn't get, and that they don't get caught up in. And I hate to give them this sense of, people are gonna be critical of them, but I think it's just wise to keep track of expenses. But I think safe to say what you're doing right now is you may be eligible for certain benefits under the categories of funeral, under the categories of medical, under the categories of, loss of, use of medical devices, earnings, those sorts of things. Yeah.
And so we just, on the therapy end, we get them longer term, so we often hear about, like, we're gonna do a civil suit and it's now a year later, so we're done with everything else. Is there a certain message that you want us to send other than, like, make sure you're communicating that back to the board and keep track of what you're asking for, because they might ask for that, or is there anything specific you want to make sure that we're saying?
Well, there's a couple of things within your question, so I wanna make sure I answer it, but, so up front, we do treatment plans usually, the board will, there's upfront, there's three therapy sessions covered, and then beyond that, there's treatment plans. So upfront, CVC has got sort of this record of what's happening. If things in terms of, you know, therapy and expenses occur, you know, way down the line, you say a year later, we're outside of restitution sometimes, and if the court case is resolved, we have 92 days, I think it is, from the sentencing date for restitution. And the reason all this becomes particularly relevant is restitution, because we're trying to seek the offender, obviously, to pay back. That's where we have the offsets, and that's where it gets, I think, complicated. You know, you guys can speak to the board, and outside of restitution, I guess, if there is ongoing therapy or ongoing expense, and then there's a civil award, how does the board manage that?
We don't actively seek out the money, if that's what you're asking. We kind of just make sure that, we send a subrogation reminder, just letting them know, hey, we're aware that there may be a civil suit going on, just to let you know, kind of what Jess was saying, keep track of your expenses, this is what you've signed. And we also send them, a copy of their subrogation agreement. So along those lines, but we don't actively seek out the money. I mean, we don't have the manpower to do that, but like you said, just make sure that they're keeping track. And, I don't know, it's kind of how you guys have been doing, it's great. You don't have to give us any more information than we need, or that's not on the application.
And the victim also, just to touch base on earlier, the victim also receives a payment notification, so they know exactly what we paid out, and, you know, what's like the amount that their bill was originally to what our 80% payout was. So they should also have a documentation, so you guys don't have to provide them any more than, what you're providing them at this time.
On this same topic, I wanted to just read the statute. Recovery from collateral source. The board shall deduct from compensation and awards under this part any payments received by the applicant from the offender or from a person on behalf of the offender, or from the state, private source, et cetera, excluding death or pension benefits. So this would be in a situation where the board, I mean, this addresses that offset that we're talking about, but I can't think of a time, at least that you guys have told me, that the offender paid out and then the board offset an application or award based upon the offender payment. So, you know, I just don't know. It's there, and that's why the application materials include all that information. But I think it's also worthwhile just to have a good discussion. I appreciate the examples.
Sorry, so something you said earlier doesn't have to do so much with this, but if there is property damage, do they have to file an insurance claim before they are eligible for compensation from the board?
What do our bylaws say?
So, CVC is a pair of last resort, so it will need to go through insurance first, especially if it's over their deductible.
That was my question though, so if it's under their deductible.
I would say no, but they need to provide the documentation as to what their deductible is.
Declaration.
Okay, okay.
The statute talks about reimbursement for deductible expenses or payments above the deductible. So while it doesn't say you have to go, it more or less confers that you have to seek insurance or payment through insurance. Loss of earnings, it gets a little more complicated, and this is, the statute simply provides loss of earning as a eligible loss, or a compensable loss, I should say. But it gets more complicated in terms of the board's policies, in terms of what the board wants to see as far as loss of earnings, and as far as limitations, and the board does set maximums as well as the minimum amount of documentation that has to be provided. All right, so under our bylaws, the victim must demonstrate being medically unable to work due to crime-related injuries. The board can approve up to 2 weeks of lost wages. Wages are paid out at 80% of gross earnings. The board can approve up to 5 days of bereavement leave for family members of deceased victims. Similar to the insurance example, all sick, vacation, and personal leave time must be used or exhausted before CVC will consider compensating lost wages. Crime scene cleanup is also, or cleanup that's in the category of property damage as well. The board can approve up to $1,000 for professional removal or cleaning of residential property involved in eligible crime.
On the work loss, have you seen any changes as far as supporting victims who are undocumented? Because they don't have any of the legal documentation of their work.
Unfortunately, we would either need, a pay stub, the employer would have to fill out the lost wages form, or taxes. The problem with all of that is if they're paid out of the table, the employer usually doesn't want to fill out that lost wages form. There's not a pay stub to verify any documentation on that, so therefore, we had audited, we had no proof. So that's a huge issue, so unfortunately, right now, no, unless they do taxes and we can get that tax form. But other than that, no.
No conversations on the pipeline or anything?
Not right now.
Okay.
And the audit is a very real thing. We actually gone through one last year, which is brutal. And you know, it's very real in terms of documentation. Now, do you have to have something from Department of Labor? I think as long as no would be my answer, but as long as we've got documentation that we can legitimize through the audit process, I think it would be helpful.
There was a previous slide that addressed lost, I believe it was lost wages, in reference to the funeral burial, loss of a dependent.
Loss of support?
This one, yes, loss of support. So it's 3 months salary, I just wanna clarify, right?
Do you guys know off the top of your head? I think it's 4 weeks.
Actually 4 weeks or a month.
Okay.
We're looking at, increasing some of our policies, including mental health therapy, loss of support, lost wages. So we're looking at increasing that. So, as of right now, today, it's, 4 weeks or 1 month.
4 weeks or a month, okay, thank you.
And part of the policy includes like pay stub.
So it'd fall kind of just like the lost wages piece, just the other side, okay, cool.
Counseling expenses, I mentioned this, the first 3, I think the board will cover the first 3 sessions. And then from there on out, the board will, Jamie Nicole will work with the treatment provider to obtain a treatment plan for a longer term cycle. Just because it may be, you may find this relevant. CVC pays $90 per individual session or $45 per family or group session. Primary victim could receive up to $2,970 in counseling, approved through stages by the board. Family members could receive up to $2,070. And witnesses can receive up to $900.
So here's a question, like on a sex assault case or a pretty severe case, they go through therapy at the time of the incident. And then I know that it can be also paid for at the time of the trial and all of that. Still has to stay under $2,970 for both the,
Total amount.
okay, perfect.
So if they're doing the trial, if there's a court, case going on, you can apply for an additional 10 sessions, which would be $900 and would fall under something we call core support. And so the treating therapist really doesn't even have to fill out a treatment plan, it's just put something on the letterhead stating this is the court case, this is the trauma, this is what we're gonna be working with. And then, so that would be out of the scope of the $2,970 or the $2,070.
But under a separate application, right? I mean, it's more or less, so you've got as a
Exactly.
victim,
Yeah.
you've got as a victim, therapy as a victim, and then you've got therapy as a result of
Yeah.
secondary trauma, really.
There's like two separate encumbrances that we do.
But it is the same kind of money?
So, no, so say you guys have, done a treatment plan, you've done an extension, and all that money's gone, but they're gonna be going into, court support, that's an, excuse me, an additional $900 that we would just ask you guys to write a letter.
And do they have to have exhausted the counseling funds?
No, actually, just make sure that on your invoices, you put which encumbrance you'd like to take it from, court support or individual sessions.
Along with a letter to request.
Exactly, yeah.
Excuse me, how many members is the amount is for all family members or for each? Or
Each, yeah, yeah.
basically a family of 5.
They each get their own encumbrance of 2,070, correct, yeah. They would each need to fill out their own application and everything, but yeah, we would do their own pot of money down encumbrance.
I think what's also important about this is the actual therapist and the detail from the therapist. I look at you.
Yes, please do.
Because and I don't think it's particularly common, but we've had some challenges in the past. Whether it's, I don't know that I can specifically speak to rate challenges, but with working with what is the treatment plan, identifying specifically the treatment plan, much easier for the board and for the victim to go through this process with a well-identified plan and someone who's willing to document what are the needs and of this particular victim. I think it's crucial for us to maximize their benefit. Good questions. What's up?
For the law enforcement piece, I just want to make sure that we're doing this right. But typically I'm pretty good about like just sending them to Nicole and Jamie as far as like the therapy piece goes, with a victim, their family, trying to deal with the financial end. Is that fine if we just continue just to send them your way towards the end? Because
yeah,
it just...
you guys are doing a great job.
Okay.
Yeah, absolutely.
Okay. Okay, sounds good.
Oh, and I should mention, hang on, that we currently, there's actually a position in our office that is a manager of crime victims compensation and the bail board. That's a position that's currently vacant, so we're accepting your application. I can't do this. Yeah. So, this program, as I mentioned, works because of Jamie and Nicole. But the idea, at least with our office, is to facilitate in the customer services to have an actual manager in that position that helps manage the board, and that I can have Jamie and Nicole continue to do the great work that they do, but also have somebody that can try to facilitate and be present with law enforcement as well. So for what it's worth, sorry, I put off your question.
No, it's okay. We get a few, I'm sure other jurisdictions too, we get cases where officers get assaulted. I had a particular case where a police officer went through workers' comp to get therapy, and then they told her that she could no longer get therapy through workers' comp. So I was trying to advocate for her to get crime victims compensation. However, I was told by, is it our commander?
Yes.
Our commander that because it was a work-related injury, they're not eligible for crime victims compensation because they signed up for the job.
So it was a crime or it wasn't a crime?
She was assaulted. She almost got run over.
Yeah.
So
that's pretty bad advice.
So and it's been happening with a few of our officers, and so my question to you all is, what do we do in those situations? Do we give them crime victims compensation, or we don't give them because they have to go
We've
through?
actually considered law enforcement officers, and we've been in a sort of an awkward posture before of having, we've got a law enforcement officer on the board, and then we have an officer within the jurisdiction so we have to do some conflict management. So I know we've had those claims before. I certainly wouldn't say that officers are exempt from,
So then what is your what do you advise us to do in situations?
Give them an
like that?
application.
Give them the application.
We would absolutely ask for all their workman's compensation. I actually know the one you're talking about, but we would ask for the workman's compensation. If for some reason they were denied workman's comp, we would just ask for that, documentation, in case we were to get audited, but, we would gladly pay for the therapy if for some reason they were denied and the board found them eligible.
The challenge becomes, I would imagine, I don't know the officer, I don't know anything about it, but, we do have a high volume of victim officers, or officers who are victims. I would imagine one of the challenges becomes compensable crime, because, a lot of times the challenges we have in terms of filing cases against officers, they involve an assessment of, was it intentional, was it a reckless crime against the officer, or is it somebody trying to get away? Because that's a different assessment if somebody's trying to flee from an officer and an officer gets hurt in the process, which would kind of tie back to workers' compensation, which is why we need that information from workers' comp, so that we can help manage, even if it isn't a case that we were able to file. So we, guy's drunk and tries to drive away, an officer somehow gets injured in the process. We may not have the evidence to prove an intentional crime against the officer, but we may have enough to say that's a compensable crime under the statute for purposes of crime victims compensation. I would never say that's part of the job. That's just, that's somebody that needs an education, and I have no hesitation saying that. I really don't.
He does.
It's hard enough to be an officer. I get it all the time from our office because officers have a challenging job, but I think that makes it even more challenging. So I would encourage you to help correct that. And I'm more than happy. By the way, I mean, you can send them to Jamie Nicole, but you can send commanders to me. I'm happy to talk to anybody about.
Yeah, and it was both her and I who were in that conversation, and I was doing my job advocating for this officer, and I thought it was, sorry for that word, but I thought it was bullshit.
Yeah.
I did, and I still think
we don't use that word here.
And we were just shut down, end of story, move on. Sorry.
If you want some of the resources that are outside of all of this too, because sometimes they're petrified to go to something where it's documented on paper somewhere. We have a list of counseling services that cost them nothing, so they could kind of go on the outside without everyone knowing what they're doing. So if you want me to email that to you,
Yeah, that would be
please
great.
let me
Thank
know,
you.
okay?
Thanks, Jim.
Thank you.
Things that are not compensable losses. I think this isn't borne out specifically in the statute. The statute includes compensable losses, and then sort of by implication, these are things that we see in applications. And so we've identified a number of things that are common to us in an application, and we'll just simply say these are things that are not covered. I think phones are a big one that we often see. Other than the stuff here, are there other things that are pretty common that you guys we're seeing in applications that these folks should know?
This is a pretty good list, but sometimes they'll just even make their own check mark in their own box and then just write what they want. I can't do that, but, or their money was stolen and they want all that money back, like we can't replace that money, has to come from somewhere, so, this is a pretty good list. Rent assistance has been really big,
And travel.
yeah, travel to the courthouse, that type of thing, so we usually just send them over to their advocates, so.
But moving or relocation costs are still?
Well, we're still not doing that.
Still not doing that, okay.
Yeah.
So what I will tell you, this is outside of comp, but Jalen brought up other resources. There are a number of other resources, and I probably don't even need to tell you folks that, but one of those resources that we really haven't utilized probably as much as we could is the Witness Protection Program. The DA's office administers the bail board, but the bail board operates separate from the DA's office. The DA's office has its own grant, application and as a grantee, a bail grantee for, it's a relatively small amount, but it's for witness protection. And so relocation, rent assistance, we just, I think I've processed 2 or 3 in the last 6 months. We've had years where we didn't have any applications. In those circumstances, all we're looking for is information from either law enforcement and a prosecutor or one or the other, usually, that is familiar with the case, familiar with the victim's circumstance, and then the victim fills out the information as it relates to the necessary expense and plan. There's got to be a general plan for, say, the relocation and an upfront security deposit. That's usually what it is, I need $1,100 for a security deposit so I can move out, those sorts of things. And there's also a state witness protection program that's the Division of Criminal Justice administers, which those are take applications for more high profile or more significant crimes, retaliation, stalking, that sort of thing.
Question. I had a case about 2 years ago where I needed the witness protection, and the supervisor who was, I guess, in charge of that didn't even know what I was talking about.
We currently have a vacancy. Again, it's communication.
Who do we direct to?
Yeah, is there like a certain contact that we would reach out to? Because we.
Me. These ladies are familiar with all things victims' compensation, but you're always welcome to call my office, and Jess is my name. And I don't. I'll put up my phone number up here so you guys have it.
Are you sure you want to do
Do you have any idea who I talked to on a daily? Actually, if you're 303-835-5620. That's my direct line. 303-835-5608 is Acacia. She can always get a hold of me. 5608. And I can help direct your questions. I'm more than happy to do that. It's a function of just communicating, I think, and knowing the resources. And over the years, in all of our agencies, we lose folks who have knowledge and experience, and then they take it with them. I think the more we can share in this setting or others is important. Somebody else had a question.
I actually just wanted to give you guys a shout out for the witness protection program, because we have a client who we could not get protection, and she's been a victim in multiple counties by the same man who finds her every single time until now, and she's being protected by Adams County, and it is probably one of the best situations that we've ever had with because our undocumented women, there are no shelters. There are no shelters for them. Sorry.
No,
he has found her every single time until now, and so and he's a U.S. citizen, so he can do what he wants.
That's great. Well, I appreciate you sharing that. Not having a shelter in our jurisdiction has been a particular challenge for us, as you guys know. But I'm more than happy if reach out. I'm more than happy to help. If I can't figure it out, I'll find somebody who can. I'm not too bashful to say I don't know and seek out other resources. There are state, like I mentioned, Division of Criminal Justice. There are state and broader resources outside our jurisdiction too. I mentioned this. These are the board is comprised of volunteers who dedicate a lot of their time. They're appointed by the district attorney. So Dave Young's appointed these folks to the board, and then our policies, our bylaws set up the terms. Actually, the statute might limit their terms too. I'm not sure, but they serve. Is it 2 years? 1 year?
3.
Thanks. They serve 3 years, like I said. And we've got great folks. We've always had great folks on the board, so I'm real proud of our membership. Do you ladies want to talk about the questions up there? It takes 30 to 60 days. Is there, you want to detail any other than the obvious?
We do say 30
30 to 60 days, because there's, things that we're waiting, sometimes the application just isn't complete, sometimes they don't understand the last page that we asked them to initial, so we have to kinda, give them a little bit more direction on that. We're missing information, like, sometimes they don't put all the crime information on there, so we have to do a little bit of detective work.
Also, we have to wait for, official police report to come in, so we have all the supplements. If there's the nurse's notes from the doctor's office, we want to have a full understanding of what happened with their victimization, so we can present it to the board. So that's exactly why we have the 30 to 60 days as to why we're waiting before it even gets seen by the board members.
We've had issues, because obviously with undocumented victims, we also are looking for JD certification. That where the police report obviously is not released to us if the case is gonna go to the DA's office. Like, is that something, can we say, like, we tried to get the police report, but they're not releasing it, and then they'll release it to you?
Regardless if we receive the application with a police report or without a police report, we're still gonna request it ourselves through our agency, with the records departments within the rightful police department. So, we'll make the request also on our end if it doesn't come with an official police report. So don't worry about that if you don't have access to it, because Jamie and I will request that on our own.
These are our revenue sources, but it's mostly through the federal grant fund and court costs or assessments to court proceedings, which it's like $163 or something for a felony, and I don't know, half of that, 70 something for a misdemeanor. These are just what we recommend when meeting with victims, that you advise them simply that the board independently makes the determination. And I think, you know, also communication availability is important. We have a lot of, I commend the work that you do with victims again. Customer service is not our strong suit in my office, and I'm the first to recognize that, and for years I've you know, tried to address that and try to improve that, and so I welcome from, whether it's from you or from the victims themselves, comments on how we can improve. Obviously, when you're filing almost 6,000 felonies, as I said, over 30,000 traffic misdemeanors, there's a large volume, and we now have 79 prosecutors in our office. You know, sometimes I think the focus on prosecution and being a lawyer, unfortunately, takes a back seat, or it actually should take a back seat, but doesn't, unfortunately. And customer service is what takes a back seat. And so I think a lot of times we have victims who you've worked hard to establish a rapport and a relationship with, and then, you know, through the handoff or through the court process, it gets increasingly frustrating, and anxiety builds, and it becomes challenging. So I really appreciate the way you all develop rapport and work with victims and help us work with them as well. But these are, you know, some of the things that we try to encourage, because we do the same training for our DAs in terms of comp and what comp provides, and then there's a legal aspect of the challenges that they face with, you know, restitution and those sorts of things, and keeping claims confidential. But one of the challenges that we run into is misunderstanding. Victims, obviously, in a point of trauma, may not process everything that you're telling them, and so then we get them, and so it gets stuck. There's times when it gets there's some miscommunication. So in an effort to try to clarify any confusion, that's why we want to communicate with you and offer, you know, our insight, and reach out to us if there's things that we need to communicate or we can communicate better. But we generally just keep it to the point of that, you know, it's statutorily eligibility requirements, and then the board independently makes these decisions, and then it does take some time. You know, we have these hypotheticals. I asked Jamie and Nicole, why are these in here? But they're challenging. The board faces these challenges of determining eligibility. I don't know if you guys want to do these or not, but until somebody, I guess, walks out. So Ted's a legal citizen. He's transporting undocumented persons, not wearing seatbelts. Ted is hit by a drunk driver. The van rolls. The other driver is uninsured. Ted suffers injuries. One of his passengers dies. Several others suffer serious injuries. Everyone in Ted's car applies for compensation. 2 of them applied 2 years after the incident. Is Ted eligible? Are the passengers eligible? What are the eligibility requirements that need to be waived? Would your interest change if the other driver was not DUI? This is an example, I think, of a messy situation, but that's not uncommon our board deals with. Our board deals with claims from multiple victims or from maybe a contributory person who may have contributed, like in this case, Ted. Is Ted committing a crime? I mean, that's a question. Is he contributing to the crime? The other driver, clearly a DUI. If this was, eliminate the trafficking fact out of this scenario, there probably would be little question because it's a DUI and it's an eligible crime. But then you add that element to it and it becomes challenging. And I appreciate some of the thoughts and questions about undocumented folks because we deal a lot, or our board does a lot with those considerations. So these are the board, every time they meet, go through these sort of gymnastics of what are the eligibility requirements? If there's a crime committed, is it an eligible crime? Is the victim or the applicant contributed? Has that person contributed or somehow provoked that crime? A minor is taken from her home after a law enforcement search warrant or something. The parents are manufacturing meth. This child is permanently placed with a relative. 2 years go by. She tells her relative that she was a victim of sexual assault with our folks' friends. She doesn't know who the man was or how the parents knew him. They talk to police, and the parents deny the incident, and more or less there's no crime or no charges filed because we don't have a suspect. This is another tricky kind of an application that the board, I think the question here is, or the emphasis here is good cause. The board would have to really consider, in terms of the therapy expenses and those sorts of things, good cause to waive the application time period, as well as waive, the issue as it relates to the crime, eligibility of a compensable crime. And so we really have to be assessing what documentation the board would have to review. That's a particularly challenging.
That's child abuse, because she was in the presence of a manufacturing of controlled substance, right? So that's a.
The question is, is there a crime charged that relates to, the compensable loss? That's the question that the board would be.
One of the things the application says that charges do not have to be filed for them to receive compensation.
Right.
So I think in this case, she probably would, even if, because she and her aunt were cooperating with police, she just can't remember who it was.
Right.
Are there 2 crimes or just one? Like the sex assault is one, and then with the meth exposure, the other
There's definitely 2 crimes. These are what the board's gonna wrangle with. What are the crimes, and are the losses, associated with the crime? Are they not? Is there good faith to justify therapy or whatever the expense might be?
So in this case, I think she'd even be eligible twice, because the first one happened 2 years prior for the child abuse, and then the second one would be the sex assault on the child 2 years later, so she could then apply again, right?
Assuming we identified it all at the same time, it'd probably be one application that would consider, everything. We'd look at everything in the one application.
And I know we just had a case, and I don't think we've gotten word on it yet, but do you have thoughts on the child abuse case that maybe there's not, with this obviously there would be, because there's drugs, but we have a lot of times where there's a child abuse case that's just on social services and the police, because the charges are all happening there. Do you have thoughts about the willingness of the board to take CP CPS reports versus.
Assuming, is this, in your scenario, so law enforcement investigated but is not filing charges or what?
Well, in my scenario, there was trafficking that's being handled in Denver and they're not paying for secondary, so there was also child abuse charges for my client, who's a secondary victim, but they're just through Adams County and, so CPS and not law enforcement, so we submitted along with the caseworker and hopefully sent over the CPS report for the physical abuse to the child that never went through law enforcement.
Yeah, that's something the board would look at, for sure. Yeah.
So, I want to take you back a little to the customer service part, because I see we're walking away a little bit from that, but, one concern in recognizing the efforts for the bilingual or Spanish translation, interpretation services that are provided. We also noticed that sometimes Spanish, especially communication, written communication.
Welcome back. How can I help you?
I'm sorry. It's very hard to understand. And I have received calls from clients saying, I got this letter in Spanish and I don't understand. And when I read them, yes, they're in Spanish. I can recognize the words. And I can see Google Translate working, but even I can understand what has been said in Spanish. And we have, what we do is ask the advocate or whoever sent the letter is, can you send that back to us in English? So then we can explain what's happening. So in the customer service area, are you thinking of, or what are the?
That's something that we've recognized, and we've gotten several comments on. We have a software provider that does use Google Translation, so me and Nicole aren't bilingual, but, it's something that we're working on to try to, find an interpreter to interpret all of our letters.
Because I think even it's useful to send both.
Yeah.
So we can help. When people receive something, they usually, I don't want to make it bad, but some people have difficulty understanding even a legal document is. So we play a huge role in that, but I think that the feeling of they send me something that I don't even get, so am I really being helped? You know what I'm saying? So just a, subtle, message, I think. But even maybe that would be in the meantime a good measure is to send in both languages so we can provide.
Yeah, we'll definitely start doing that, and we're working on the Spanish letters as we speak. We've kind of been working on it for a couple months, so.
Yeah, and I know it's hard, and it's not criticism, but just,
Thank you, yeah.
Definitely something that is worth looking at.
I appreciate the comment. What I was going to say is helping us identify what letters, and it sounds like Jamie knows the letters that you're talking about, because statewide, there was an effort about a year ago to translate a whole series of letters, and these are the automatic letters that generate, the victims get bombed with paper once the case initiates. And so those statewide, those were translated into Spanish, and this sounds like you're talking about a different number of letters, but we need to identify what the problems are, or what those letters are, because statewide we need to correct that. If it's something specific to our compensation program, I think that's relatively easy. We can work on that. So I'd encourage you to help us identify what letters you're speaking of, and in the interim, we can absolutely send a regular English copy. Thanks.
How do your letters get generated? Is it just through the computer?
It is, so we have a separate software system that's just confidential from me and Nicole, and they are done by Google Translate. So even though me and Nicole can put it even into Google Translate and it makes sense to us, it's the way I understood it when talking to a couple bilingual individuals is that it just doesn't make sense. So an update with our system kind of messed everything up.
It doesn't work.
Yeah.
So it misplaced them when it translates it back to our system after it goes to the Google translation.
Yeah, so now we have to go and find somebody bilingual to redo all of our letters, so.
I had never Spanish, and I'd open them up and there was like 9 pages of like this approval for the therapy, and then this approval for the medical, and then this approval for something else, and they were all separate documents, and they're just like, what is all of this? And I had never seen it.
And that's how our software, we're also looking at getting a new software provider, but our software right now auto-generates when somebody's approved for something, so we kind of don't have control of that. But at the end of the year, we're looking at making a couple different changes in that, and that'll simplify the process for the victims, and we're actually able to give input to our new software providers, which is very helpful.
You know, it just, like having you guys like tell us your side of everything is super helpful, because you know, it's so easy for us to sit on our side and be like, why don't they do this?
Right.
Why isn't this? And you know, until you walk a mile in somebody else's shoes, you have no idea the struggles. So I really enjoy it.
And our software provider too, just to let you guys know, like sometimes we'll just be out for like a week at a time. So me and Nicole are like scrambling. There's 2 of us, so we're trying to scramble and do this here and this here. So if we don't get back to you, we don't call you, we're not ignoring you. We are just really slammed. So
Or we don't have a system.
Or we don't have a system to look up your company. So, but yeah, we're statewide. They're making some huge. We got a huge grant. They're making some changes. So.
And Jamie and I are sitting on the board so we can actually put our input in and hopefully we'll be able to
Simplify it for all the
Absolutely.
victims too, so.
Jimmy and Nicole have asked to work Sundays, and I just don't want them to.
I almost came in on Monday.
It was rough. Monday we really needed to come in.
Almost came in.
You sit home, it's more stressful on your days off.
It
because you know what's
was.
building up.
It really honestly was.
It's been a rough week.
Can I wanna make a suggestion to all advocates and also your office, just in the context of the new public charge rhetoric that's going out there, like none of these benefits are going to impact an immigrant on their applications, but they believe that they will. So like they come to our office and they think that if I represent them for free, that they're gonna get in trouble with immigration, because of the public charge, rhetoric, and I think that they believe that the counseling that's paid for as victims is also a public benefit, which it's not, it's victims' compensation. So if you get people who are undocumented, who are hesitating to apply for these benefits, like, if you can't get through to them, please feel free to send them to us, like, Rocky Mountain Immigrant Advocacy Network, because we are, like, literally trying to nip that in the bud, because they are obviously eligible for them, and it will not impact their immigration case, but that's not what's being said. And by law, they cannot impact them. So I just want, like, if you get a victim hesitating, that's probably why.
I know we're experiencing that with visa applications too. Thanks. Okay, one more. Do you guys like these? These are, Nina told officers that her cousin Bob is living with her on and off for several months. She's a recovering cocaine addict. Bob's drunk, wanted cocaine. He gave her $40, loans her his car, and asked her to go pick up cocaine. She leaves, stays at the dealer's house several hours, smokes all the cocaine that she purchased with Bob's money. She came home, Bob's upset. He doesn't have money or cocaine. They get into a fight. He grabs her, pushes her against the wall. She gets injured. She tried to call 911. Bob grabs the phone. Is Nina eligible? Are the eligibility requirements that need to be waived? Is Bob eligible? That one's kind of.
These aren't true scenarios.
We just changed names,
so they're.
Protect the innocent.
Yeah.
Yeah, this is one the board didn't pay out.
Did not.
That was the way wrong. Did pay out or
That
did
was-
not?
Did not.
I just wanna give a quick, well, first of all, you guys are so great, and I feel like we meet you all the time, and really appreciate you. But I just think that the board in general in Adams County, we've had such, mixed experiences with, across the metro area, but other states too, with
kids who recant and sex assault stories and having to pay money back, or DV victims who provoke the attack because they know it's coming and they want to have control over it, getting denied in other places even though they're really injured because they mouthed off. And I feel like Adams County is pretty, like out here, the board is just pretty lovely at.
Thanks for saying that, because our board, we really love them, and they really do work within the best interest of the victim. And they even had that conversation, we had a board meeting on Tuesday, they even had that conversation about like provocation of a victim and protection order type of situation. So they don't always agree, but they do work in the best interest of the victim.
They have really hard discussions on each and every claim.
Yeah.
I appreciate that.
That's our website, if you don't already know it. Yeah.
I have a
Can I turn the lights on?
detailed, specific kind of question, but, so I don't know if it benefits everyone in the room, but, maybe the lawyers in the room can help with this. So, we had a client that filed a civil lawsuit, and the attorney wanted our, records of, how much she had incurred in counseling bills, even though we billed CVC and they paid out. The lawyers referenced the Colorado Made Whole doctrine about providing a letter saying how the monetary amount of sessions that we provided, but excluding the part of who paid it, not referencing that CVC paid out on it, citing that there's protection for victims in these civil cases around the damages they incur and not being able to seek full losses because insurance paid out or they got various places to pay for it. And I just hadn't come across that before, and so I'm wondering if anyone else had, and if that is standard.
I don't know the Colorado Made Whole. It sounds like a civil lawyer talk.
Yeah.
So I'm sure that's a thing. But what I've dealt with here is similar claims or challenges as it relates to restitution. And a lot of times what happens is they'll happen in, not my cases, but then I'll hear about it, so I kind of jump in, or we'll get a public records request under the Colorado Criminal Justice Records Act for the CVC stuff. There's the statute as it relates to confidentiality under CVC is what I would primarily refer to, because it's easy, because it's specific to victims' compensation claims, and then it cites in the statute that only if a court makes a finding in a civil case, if there's a reasonable necessary need or something along those lines, or in the restitution paradigm, that there's got to be the defense attorney must make a showing of sufficient cause for those records to be turned over in camera, meaning they're confidential and the court reviews them and only discloses them if it finds any sort of discrepancy or need. So the easiest thing, I think, is to refer, and I can do it.
But this was the victim's lawyer that wanted.
Exactly.
Okay.
I don't know why would the victim's attorney want that,
I mean, my sense was they were filing a civil case, and are trying to present what all of her losses and damages
So the
were.
victim can provide that information as the protected party.
They can, yes. But my
their
question
attorney.
was, is it okay to provide documentation that this is the amount she incurred in counseling charges? She didn't actually pay any of those.
Right.
CVC did.
Right. So CVC would keep all those, and what I would then, in your situation, is I would simply refer back to CVC made the payouts. CVC has that information, and we're basically the holder of the record as it relates to those payouts. And 24-4.1-107.5 is the confidentiality statute. And so when they reach out to me, then I will say these records are confidential. I can tell you the number of the payout, so that I can disclose as a matter of a public record that there was a comp payout of $10,000 for funeral burial. That's it. So they would then have to, the statute says upon a strict showing to the court in a separate civil or criminal action, that particular information or documents are known to exist only in board records, is when the court would receive that information or require that information be disclosed. And so what I've generally responded to is just this kind of form letter saying, here's the statute, we're not gonna provide anything, and what I've done is to try to balance it, is I've said, as a matter of public record, I can tell you the payout is, this amount, because it's our court associated with a criminal case usually.
Can you read that statute number again?
Yeah, 24-4.1-107.5.
So now could they, it sounds like you guys are protected under CVC by statute, but the defense decides to do a FOIA request on our side of things. Any communication, would that backdoor in and open up potential for conversations we have with them? I mean, there shouldn't be any confidential information about the payouts or anything like that, but.
Well, I mean, I think when you say communications, if it's written email, communications concerning the case, then generally speaking, those are always open records. If it's a pending case, then I think it depends on, I would ask you to refer them to me if it's a pending case. That way we can kind of control who's the custodian and who turns those records over. But if it's a question as it relates to, do you have a claim or is a claim filed? Yeah, that's probably technically a communication or a writing that's an open record. But the substance of what they're requesting is not. So to answer your question in a simple way, I think if it's a pending case, forward them to me as the custodian, and then we'll sort that out. If it's a closed case, then I think you have to refer back to your practices and what you turn over as a public record of a closed case.
Because we had that conversation the other day. I said, I don't want to email you anything about the case in any way, shape, or form, because I don't want it to be pulled through a FOIA request. So I'm like, when you get a second, call me and we'll talk about it, so that way I don't have anything in writing that can be used against the victim in any way, shape, or form. But we've always emailed the applications. I mean, there's nothing really in the application that.
Well, the application would also include, be covered under the confidentiality statute.
But it could have addresses or email addresses that would be turned over to the defense, and then the defendant would have all that information. So maybe I won't email at all. I just don't want to open up having loose ends. I just want to protect all the parties the best we can.
Yeah, unfortunately, in the public realm, we learn the hard ways that everything that we communicate is subject to at least an assessment of is a public record, and more than likely it is.
FYI to any of the other law enforcement advocates. Be very, very careful what you're putting in there.
On that note, do you have any, Nicole, Jamie, do you guys have any feedback for us in general, like things that we could do better, or things that could be helpful, or?
We think you guys are doing great, but we would like to, we talked about it this morning, we would like to maybe come to each of you guys and do like a separate one, because there's outside of the realm of everybody that's here, you guys process emergencies and you guys deal with those individuals on a face to face, so we would like to talk to you guys a little bit more about maybe just our policies concerning emergencies.
And a lot of changes are gonna be happening here probably in April, May-ish time, so we wanna just touch base with all the advocacies, and go over those policies at that point, and then just kinda have some fun with it and just, test our knowledge and go through that. So we're hoping to, set up some training probably April, May-ish at that point.
But until then, please, let us know.
Call us.
Yeah. Or
email us, fax us, we're here.
Age me.
What else? All right, I think there's I don't know why it keeps. You guys put your phone numbers in here. I already gave mine.
And the website is up to date with all our information also. We just made huge changes with our website, this month, so it's all up to date with all our new documents, and then
Policies, bylaws.
they'll be updated again in April with the new stuff that's coming up, so FYI on that.
Alright, so those are contact numbers, and I gave you all mine. I'm happy to give you an email to, I just don't have it up here, so you can come get it from me after this. Alright, thanks everybody. Thanks for everything you do.
Thank you.
Nice meeting you guys.